it's a little bit like we're going to take away your stuff first and then have a debate about whether that's okay, where you have to pay, and we'll use taxpayer money, and let's see who can last longer.
The Expropriation Bill is currently before Parliament. What risks are there to South African property owners? Well, I asked this question to Gabriel Crouse of the IRR in a recent episode of my podcast, Solutions with David Ansara. What follows is a short extract from our longer conversation. You can watch the full interview with Gabriel by clicking on the link in the description below. Enjoy. All right, so let's look now at the legislation itself, the EWC Bill. Could you provide us with a bit of detail on that, and what are some of the potential risks as you see them, Gabriel?
So, I mean, there are a few more technical concerns with the bill, but the headline basic problem is that it allows for nil compensation. Section 12.3 allows for nil compensation after expropriation or as a result of expropriation. That's just going to have devastating consequences both for the direct targets of EWC and for the rest of the country too. I'll say that the secondary concern is that this bill, but not very much second by much, it's almost just as bad, maybe is just as bad, also goes towards allowing for expropriation at below market value compensation. In ways that I think just as much abridge the just and equitable clause of the Constitution. So if someone comes and takes your house and it's worth R1 million, and they say, well, it's not nil compensation, I'm giving you R1,000 for your house. It's technically better than EWC, but
it's all quite dissatisfying for the person who's had their property taken away.
It's not good. It's not good enough. So maybe I'll just walk you through 12.3. It says that nil compensation may be just in the following circumstances, but not limited to these circumstances or scenarios. And then it lists 5 circumstances or scenarios. So the first problem is the fact that the list is not closed. This means that courts can be asked to take things into consideration that haven't been made explicit in the law.
So it says including but not limited to these factors.
Yeah. So think about it like this. One of the arguments that we hear from proponents of this bill that have been leveled against our submissions to Parliament, criticizing it, one of the arguments has been, look, the IRR is being alarmist. They're saying that this bill is going to really profoundly undermine property rights, but they're not attending to the fact that it's sort of been very well ring-fenced, that the law is precise and concrete, and that the courts are going to come in and protect you in so far as there's any room for interpretation. Now, on the first matter, the law is not precise and concrete, or insofar as it's precise, it precisely says, there are all kinds of things that we haven't even been able to think about, and that you might find interesting if trying to justify why someone deserves nil compensation. Insofar as the courts can be relied upon to weigh against that in a just fashion, I think it's worth bearing in mind that even if you do go to a court that acts justly and correctly, it's very expensive. A visit to a regular high court with senior, you have to bring an advocate, an attorney. This is not like a criminal case where the state is going to provide you with free legal counsel.
It'll be a civil dispute, right?
For a lot of people, they're going to be sitting with costs that could easily exceed the value of their property.
And the state would have access to taxpayer-funded legal counsel that is essentially limitless.
Yeah. So you really have I think as our colleague Dr. Anthony Jeffrey, my colleague Dr. Anthony Jeffrey, one put it, the behemoth of the state pitted against the puny citizen, and procedurally there are problems. There have been sort of subtle amendments, and they're going back and forth. I should say that the vote on the final language will take place on 14th September. That'll be the end of the committee process, and then it'll sit on the National Assembly's floor. So we can't, I wouldn't want to get too lost in the particulars of the language because that hasn't been finalized. But in some versions, and in fact, as I read it in the version that we're still sitting with, there are important rights in use of the property that can be removed before the court process has been completed. And that your title deed can effectively be taken away before the court process is concluded as well. So, it's a little bit like we're going to take away your stuff first and then have a debate about whether that's okay, where you have to pay and we'll use taxpayer money and let's see who can last longer. I think there are real concerns, even if the law was well written, about your odds of getting a standard just process outcome out of that process. But then when you see that the law is not even prepared to limit itself to particular circumstances, that concern is even worse. That all being said, the nil compensation clause seems to say that it's limited only to land, insofar as it's limited to anything. But again, it's not limited. So the only it says nil compensation can be paid for land. And so that might make you think, well, at least there's some protection. The improvements on the land are never going to be things that you can expropriate without compensation. Here's the problem with that thought. I mean, I think it's a good thought, but there's a problem with it. And the problem there is something called the principle of accession, which is basically a technical term for once you have attached a piece of a property, an item of property to another item of property in such a fashion that you can't really undo it without basically breaking it, then they become one item of property. So in factories, there's some fridges that can be removed. And then if you buy the factory, you don't get the fridges, you have to pay extra. But with other factories, they might be so embedded, sort of set in concrete. This is one of the cases that was set precedent for this, that they are included in the property. So obviously houses, warehouses, dams, irrigation systems, hotels, factories, all the kinds of things, homes that might be expropriated, they could, through the principle of accession, be considered in some contexts to be part of the land because it's one and the same property. It's reflected in the same title deed. Which is, the sort of guarantor of that property and names its features. And under that interpretation, EWC is still around for land and improvements, which, it's hard to sort of be worse than complete erosion than the kind of erosion of property rights that occurs when you have EWC. But it obviously is worse if immediately improvements are also on the chopping block.
Thanks for watching. If you enjoyed this analysis, you might want to check out the full-length interview with Gabriel Crouse. That's linked over here. And for more long-form conversations, you can also follow my other channel. That's linked over here. My name is David Ansara. Until next time, take care.